I want to welcome all of you to our, I don't know how many this has been, it's at least 5 or 6 now, annual Landlord-Tenant Forum for the public. This is one of the most important things that we do in the year out of the City Attorney's Office, and we're really glad to be able to meet with you all. I want to tell you first of all about this microphone, because you may notice that it's not making me any louder. But it is here for our friends from City TV who are recording this event and who will make it available for viewing and streaming later on. So we thank City TV for being here and doing this for us. And this looks sort of like a useless toy, but it is actually going to make things audible later with City TV. My name is Adam Rudinsky. I'm the Chief Deputy for the Consumer Protection Division of the City Attorney's Office. For many years, our office has worked closely with landlord and tenant groups in Santa Monica and throughout California to promote housing rights, promote fairness, and to work with all sides of the issues to see that there's fairness and justice and that everybody is treated fairly. I know that landlord-tenant issues and rent control have, of course, been a source of contention for many years, part of what makes Santa Monica famous or infamous. But we really do try to work together, and I know many of you personally after all these years, and we appreciate you working with us and coming out here to share your questions and hopefully get some new information. There's always new stuff going on in landlord-tenant law in Santa Monica, and this year's no exception. So I put this event on with our friends at the staff from the Rent Control Board. Before we get to the event, I do want to thank the amazing staff that helped to make this happen, because it didn't just appear out of nowhere this morning. Our staff at the City Attorney's Office, Johanna Rodriguez, Cindy Garcia, Bridget Garay, and Andrea Kavanaugh in particular have been working extremely hard to make this happen, get all this wonderful food and refreshment for you. As I said, our friends from City TV are also recording this, and Dan Costello, one of the chief people at the Rent Control Board on the second floor, has really helped to plan and make this happen, along with Tracy Condon, of course. I want to introduce our first speaker, who is one of the, I don't want to say new anymore, but one of the amazing go-getters working for housing rights in Santa Monica. She's an information coordinator with the Rent Control Board. Please welcome Morena Zelaya.
Hi, everyone. I'm Morena Zelaya. As Adam said, I'm an information coordinator with the Rent Control Office, and I'm not new anymore. It's been 2 years, a little over 2 years, and there's newer people than me now. But I just wanted to sort of give everybody a basic overview of the rent control law in case there's anybody who's a little bit confused about it, though it's been around for quite a while now, as most people know, and then just give some new information about regulations that passed this year that people may or may not have heard about. So I'll just get started with the brief history. So rent control, as most of you know, passed on April 10th of 1979. So there's 2 types of tenants really in Santa Monica. If you're a pre-January 1st, 1999 tenant, your rent and amenities are based on what was in effect on April 10th of 78. And if you're a post-January 1st, 1999 tenant, it's what we call market. So whatever you and your landlord agreed to at the beginning of your tenancy sets what your rent is and what your increases are based off of. So rent control controls the rents. So once you've got your initial rent, we control what the increases are. Along with the controlling the rents, we also, we provide remedies for tenants and landlords in sort of common situations that arise with regards to maintenance and repair issues, possible excess rent when people are confused about what they can or cannot charge tenants. So if you've got things like a repair issue that needs to be taken care of and you and your landlord are sort of in disagreement about whether or not this needs to happen, a tenant can come to us to file what we call a rent decrease petition. And it's sort of to, tell, to encourage facilitation between the landlords and the tenants in order to get the work done. We also provide eviction protections, or the rent control law extends eviction protections to tenants in Santa Monica. So you need a just cause to evict tenants. Just causes are, the big ones are things like non-payment of rent or breach of the lease, being a nuisance. Things like the end of a lease are not a just cause. So if your lease says, it runs from one day to the next year, just because it ends doesn't mean that a tenant has to leave. So that is something that confuses people. And we get that question a lot about whether or not, the end of a lease is a reason to ask someone to leave, and it's not. So that's something to keep in mind. The rent control law also controls the rental housing stock. So there are limited reasons as to why a controlled rental unit can be removed from the housing stock. And you do need permits, a removal permit, if you were to want to remove a rental unit. And then one of the just causes for eviction that's not a fault of the tenant is the Ellis Act, which is a state law that it does allow for the removal of controlled rental units. So there are methods in place for removing rental housing, and we'll get a little bit more into that later. Another no-fault cause for evicting a tenant is evicting for owner occupancy. So let's say an owner wanted to move onto the property, then an owner could potentially evict a tenant for owner occupancy. There are, again, rules regarding that and rules regarding who the owner can evict and how much notice needs to be given and if, or how much permanent relocation needs to be paid out to tenants. So it is a legal process. It's not something that an owner can just go up to a tenant and say, I want your unit, so you have to leave. There are steps in place that must be followed. So if you have any questions about that, you can definitely come to us at Rent Control and we can provide more information about whether or not steps are being taken properly. So as I mentioned, we do have a number of petition processes that landlords and tenants can start with our office for various reasons. The rent decrease petition for things like the removal of an amenity. Let's say you had parking, but your landlord has given you notice that they are taking your parking away. You can come to us and file a petition for rent decrease to make up for the fact that the rent that you're paying is not giving you the all of the amenities that you had been that you had since the beginning, basically. Same thing with the maintenance and repair conditions. If things aren't being repaired, if things aren't being maintained, the rent you're paying, the rent a tenant is paying is not getting them what they had initially been receiving for that rent payment. So we see it as a way of sort of encouraging the repairs and maintenance that may need to be done. And for rent control, it's not, for rent decreases, it doesn't have to be something that's, a housing code violation like no heat. For things like that, your tenants will definitely want to reach out to code enforcement. But with our process, tenants can come to us for things like deteriorated paint or deteriorated flooring, things that may be a little bit more case by case. There's also, we know, a lot of construction going on in Santa Monica currently. We hear more and more about buildings undergoing major renovations. And some buildings are occupied by tenants. Some buildings are not occupied. For tenant-occupied buildings, we do have another petition process called the construction decrease petition. And the construction decrease petition is a way that tenants can they can seek a remedy through rent control because of the impacts that construction may be having on their habitability. So there's a difference in the construction decrease. It's a little bit tenant heavy. The burden is on the tenant. If work is necessary and it's being done in a reasonable manner, and it's taking a reasonable amount of time, it is different than if it's all sort of upgrades. So we look at whether or not things are being done unreasonably, or if they're taking an unreasonable amount of time. And we look at whether or not the work is necessary. But if something is happening, we are getting an increased number of calls with regards to construction in Santa Monica. So if something is happening in your building, you can definitely reach out to us and we can talk about it. We start all of our petition processes with mediation. So we hope that by bringing together the landlords and tenants, we can sort of come to an agreeable solution and mediate a settlement with people so that things don't get to a contentious point between the landlords and tenants, because we do encourage that landlords and tenants work together and try to talk it out, because it's a landlord's, it's your business, but it's also where the tenants live. So we want people to have as happy a relationship as possible. So with regards to new regulations that have started in Santa Monica this year, in early 2018, the board passed Regulation 3120, which eliminated surcharges, the property tax pass-throughs that landlords can pass through along with the rent increases. And so in certain instances, these have been eliminated. And the reason for this is that we were hearing that when properties were being sold, which is also happening a lot in Santa Monica, the properties were being reassessed, the values were being reassessed, and tenants were seeing significant increases in these pass-throughs that were coming to them through rent increases. And so you were getting people that were having $80 pass-throughs. And so the more we heard about that and the more we saw that properties were being sold at these astronomical prices, the board decided to take action because these could become unreasonable increases. And so this year, it's a little bit complicated, and I'm sure landlords who saw our rent increase notice this year were probably a little bit confused. I know we got a lot of questions about this, but the basics of it are if a property was sold or the value of it was reassessed for some reason, or a tenancy began on or after March 1st of this year, property taxes can no longer be passed through. So for any new owners that have just bought the property, even if the old owner was collecting property taxes, you would no longer be able to collect the property taxes if the property was, again, sold, or the value was reassessed, or the tenant moved in on or after March 1st of this year. So that's something to keep in mind, because if an owner continues to collect the property taxes, it would be excess rent and it would have to be paid back to the tenant. The other part of the new regulation is that we're actually going to take questions at the end. So the other part of the new regulation is that if the tenancy that you're going to pass the property taxes through doesn't qualify under those previous conditions, the property taxes are actually capped. The pass-throughs are capped at either what the property taxes themselves are, or 4% of the MAR, the new MAR, the maximum allowable rent, or $35, whichever is less. So if you got our new form this year, you saw all those 5, F, G, and then 5, and you had to do a bunch of calculations and choose the lowest one. That's why, because the property taxes are capped at 4% of the MAR, the $35, or the property taxes themselves, whichever is less. So that's one of the big new ones. The other one is that the board recently clarified existing law regarding tenancies. So tenants, the board has clarified, it means a person means an actual human being. We heard a lot about owners potentially renting to corporations, and that is basically it's tantamount to a removal of a rental housing unit, of a controlled rental housing unit. And so the board has clarified that the rental housing agreement between a landlord and a person, that's a human being. It's not it can't be a corporation. So that's more of a clarification of existing law. And then finally, I mentioned the Ellis Act earlier when I first started, and I want to talk about both the Ellis Act a little bit and buyouts. They are two completely different things, but we've heard from tenants that a lot of they're being approached by landlords with a claim that, you have to take this buyout, or I'm going to Ellis the property, or maybe presenting a buyout as if it is an Ellis. And we just want to make sure that people understand that a buyout is voluntary. Tenants don't have to agree to a buyout. You can say no to a buyout. A buyout is a negotiation between a landlord and a tenant for money in exchange for moving out of your unit. If you're interested, definitely negotiate. That's within your right. A landlord is allowed to approach a tenant with an offer of a buyout. If they do approach the tenant, they first have to give the tenant a notice of their rights that we provide and that you can either download off our website or pick up at our office. And that notice of their rights basically just explains you have the right to rescind within 30 days of signing it. You have the right to consult a lawyer. You have the right to consult the rent control office. And you have the right to say no. Within that buyout notice is an information, there's a little diagram of permanent relocation amounts. And there's some confusion that when people see the permanent relocation amounts, they think this is the maximum that a buyout can be. That information is there just so that tenants understand what would be required to be given to them if they were evicted through no fault of their own, through something like the Ellis Act or through something like an owner-occupied eviction. It's not there to set a cap. The city doesn't set caps on what the buyouts are. Actually, if you want to see what the buyout amounts have been in the city, we do have a posting on our website on the homepage. We've got a link to a buyout page that's got averages based on the city, and then there's actually, recently we posted an Excel document that's got information about every buyout that's been recorded with us, and landlords are supposed to record the buyouts with us within 60 days of it being completed. So you can go on our website and sort of see based on where you live, based on how many bedrooms there are, and get an idea of what buyouts have looked like in the city. So we want people to understand that just because you're hearing something, maybe there's rumors going around the building that a landlord's going to tear the building down and that you're all going to have to leave. It doesn't mean that that's what's actually going to happen. So, everything that may happen, it needs to be done in writing. So if you're not getting anything in writing, definitely reach out to us. We can let you know whether or not a landlord has filed Ellis paperwork. They have to file it with us. So we can sort of guide you and and give you your options. But it really is something that people should be aware that just because you're hearing things doesn't mean that that's what's actually going to happen. And that if you have questions, we are available at the office. You can definitely call us. We're open Monday through Thursday, 7:30 to 5:30 for phone calls, and 8 to 5 every other Friday. We're closed this Friday. So definitely reach out. You know, we're landlords and tenants. We're here to answer questions that you may have. If if anything is unclear, we're obviously available to you. You can also email us. You can go on our website. We've got a lot of information on the website. So, yeah. I think we're doing it at the end. Yeah. I think we're taking questions all the way at the end.
Thank you, Morena. And just so everybody knows, we are going to have a lengthy question and answer period. And for most of us, I think that's the highlight of this event, because we learn about a lot of what's going on and hopefully can give you some good information. We've got a lot of great people in the room here, aside from just those who are speaking. So if you could just hold your questions till the end, that would be great. We're going to have plenty of time to answer your questions. I also want to thank all you guys for coming out with this weather that I know we're not so used to in LA. At about 4 in the morning, I think I was woken up by what felt like biblical proportions of rain, and we're glad that it let up a little bit so we could at least get in here. So thanks for coming out and braving the rain. I want to talk a little bit about tenant harassment, which is an issue that we deal with daily in the city attorney's office in terms of questions, complaints, cases. And just briefly, I want to take you back to kind of where that started. So the rent control law went into effect just about 40 years ago. And for the first 20 years of rent control in Santa Monica, we had what's called vacancy control, which meant that if a tenant moved out of their rent control unit, excuse me, the rent stayed at the same controlled level, right? So whether it was tenant A or tenant B, that unit would have the same low controlled rent. Well, in 1998, I believe, California state law changed with the passage of the Costa-Hawkins bill, also known as vacancy decontrol. And what that meant was a tenant in a rent-controlled unit, if they moved out, the landlord could charge any rent to the new tenant. They could charge whatever the market would bear. So a tenant paying $500 for an Ocean View apartment in Santa Monica, if they moved out, the landlord can now charge potentially $2,000, $3,000 or more. So what that created was a built-in incentive on the part of the market for rental units that these low-rent units were suddenly potentially worth a lot more if the tenants would leave. And so some owners started talking about, like Marina was talking about, buyouts. There's always been conversations about buying a tenant out. But then some owners would resort to unlawful behavior to force the tenant out. And the first law that we passed was shortly after the Costa-Hawkins bill went into effect. Costa-Hawkins actually was the mid to late 90s. Our tenant harassment law was just about exactly 20 years ago, in 1998, when the Santa Monica City Council passed a series of rules that said landlords can't do certain things to their tenants that are typically intended to force the tenant out, like just harassing them, making life miserable, threatening them illegally, committing fraud, and so forth. And so over the last 20 years, that list of harassment actions has grown a little bit in response to what we've seen and what the City Council has wanted to increase tenants' rights where necessary. The most recent addition was violating a tenant's right to privacy, which you'll see in the law. And that partly grew out of a trend a few years ago that we saw where owners would schedule an inspection of a unit that was maybe for a legitimate legal reason, such as repairs that needed to be done or smoke alarms, things like that. But then they would turn that into a full fishing expedition to look for possible violations of the lease, going through somebody's bedroom, taking pictures, that kind of thing. So the tenant harassment law has evolved a little bit over time. I want to just talk about a few of the issues that come up a lot for us with questions that we answer that might be helpful. So first of all, who is a landlord under that law? I mean, partly, of course, it's the traditional property owner. And if they directly harass their tenants illegally, then that's against the law. But also a property manager, any kind of representative of the owner is considered a landlord for purposes of that law. And also what we're seeing increasingly in this day and age of sub-renting and Airbnb and those kind of things, a tenant themselves can become a landlord by subletting to a subtenant and then harassing them. And we see this a lot. There are a lot of complaints by subtenants saying that, you know, the tenant that I pay rent to, who might be their roommate, is harassing them, either trying to get them out or making life miserable or scamming them for money or any number of things. And one of the current trends that we're seeing, and we hope we don't see too much more of, but we're taking a close look at, is subtenants who are being harassed and having their living space sort of invaded, where the owner or maybe even a tenant who's subletting to them is being in their living space when they're not supposed to be there. And it's important to remember, and I think Morena touched on this, that you know the owner of the property definitely has their business and they have their rights, and the tenant has the place they're living and they have their rights. And California state law is very strong on protecting the rights of someone to be secure in their home, to have quiet use and enjoyment of their home, and to not have their privacy invaded. But we are seeing some new complaints of sometimes owners who come around and come in and sort of without any legal cause to enter the unit, to sort of make themselves at home and be kind of aggressive in social interactions with tenants and so forth. So that's an area that we're looking closely at. Excuse me. Another issue is accepting rent. It's also a specific form of harassment for the owner or their manager to refuse a legal rent payment. Now, one area where that does come up legitimately is if there's a dispute over the tenancy, okay? And the owner may say, I'm not going to cash your checks until we get this straightened out, because by cashing the check, they may be waiving a claim that there's a problem with the tenancy. That's what's considered sort of a good faith dispute about the rent payment. But if a landlord pretends that they never received the rent and says, I didn't get your rent payment, even though the tenant paid it the normal lawful way, or if they get the tenant's payments but refuse to acknowledge them and there's no valid ground for doing that, that's also a form of harassment. And we've taken some cases to court just on that issue. It's part of being able to live in peace. So as far as the enforcement of the law, the city has folks, including our office. The Code Enforcement Division is very active these days in monitoring situations where there's claims of harassment. The harassment can take many forms. You can always check out online the Municipal Code 4.56. That's where the harassment law is located. Morena said with construction, there are a lot of issues that can come up. There's a lot of potential harassment where construction may be used as a tool by the owner to make life miserable for the tenants. If it's done that way, then it's illegal. Of course, construction itself is not illegal, but you have to follow the rules and work closely with the city on doing that properly. So we will take questions about this and all the other topics after. I want to introduce now our last speaker, who's Gary Rhodes, one of our longtime deputy city attorneys in the Consumer Protection Division. And Gary's going to talk to you about some of the new developments in just the past year in landlord-tenant law in Santa Monica.
Thanks, Adam. Thank you for that rousing welcome. I'm going to first begin with the two laws that went into effect this year They are the Immigrant Tenant Protection Act, which is a state law. That law focuses on immigrant status, and it prohibits landlords from harassing, threatening, reporting, or evicting tenants on the basis of immigrant status. The other law is actually a city law that went into effect here in Santa Monica in June, and it prohibits landlords from evicting households in the middle of the school year, households that have either students or teachers in them. Those are two brand new laws. We don't have any cases from the courts on them. I'm not even aware of any filings yet. So I'm going to delve into the legislative history a little bit so we can understand why they are needed. Now, when I said the words legislative history, I almost fell asleep here on my feet right in front of you. That's a deadly boring topic, I know, but these two laws are the exception because they have some real life examples in that history that I think will help explain the need for these laws. After that, I'm going to give you all an update on a law that we passed here in Santa Monica in 2015. It amended our fair housing law to include Section 8 participants, and now landlords are prohibited from saying no to tenants just on the basis of their participation in the Section 8 program. So before I get started, I just want to give a plug for our division's column in the Santa Monica Daily Press. Adam, Andrea, and I write a monthly column, and we cover topics. A lot of them are often tenant protection and landlord-tenant topics. We also do consumer protection. It's called the Consumer Corner. It's every month, and all three laws I'm going to discuss right now, we've covered in columns in the past. If you just go to the Santa Monica Daily Press search bar and type in Immigrant Tenant Protection Act, the column that we submitted and was published pops up, and you'll get a lot more information than what I can share with you in a 30-minute period here today. Okay, so the Immigrant Tenant Protection Act. Back in 2017, when the California legislature was thinking about this law, they were looking at an increasingly hostile environment for immigrant tenants in California. Ever since the Trump administration took over, there have been travel bans, there's been dialing back on asylum law, there's been, taking children away from their parents. Just all the rhetoric and actions against immigrants have created this atmosphere of fear for them. Now, how does this spill over into landlord-tenant law? Well, there were some, and there are still some unscrupulous landlords. And I say unscrupulous, I put that in front because they don't come to our workshops. They didn't come here today because they're not really interested in learning more. So these are the bad landlords out there that necessitate this law. They were recognizing the environment, and they were taking advantage of that fear because an immigrant tenant, in this affordable housing crisis, they don't want to lose their housing. And they don't want to do something that's going to cause themselves or their friends or their family to get arrested or deported. And so they are vulnerable, and landlords recognize that. I have from the otherwise dry legislative history, some of the case examples that the legislature looked at when they decided that this law was needed to protect them. An Oakland landlord unlawfully locked his tenants out of their home and then threatened to call ICE, the Immigration and Customs Enforcement agents, if they tried to re-enter. A Central Valley landlord threatened to evict a married couple unless the wife would have sex with him, telling them that they were powerless to do anything to him since he could report them to ICE. A San Mateo property manager tried to unlawfully raise a domestic violence victim's rent, threatening to call ICE if she didn't agree to the rent hike. And right here in LA, in Boyle Heights, there was a landlord who had for several years tried to talk his tenant, who was a single mom, an undocumented immigrant, into a under-the-table rent increase. It was in a rent-stabilized unit, so he couldn't raise the rent as much as he wanted to. And she was able to rebuff these with the help of local advocates. But in 2017, as he was reading the temperature of the country, he then said to her, okay, this time I'm serious. And if you do not, agree to this, to paying me extra money, I am going to report you to ICE. So that was an example out of Boyle Heights. This is deportation extortion, essentially. And so the law prohibits landlords from doing several things now with immigrant tenants. Those prohibitions include asking tenants about their immigrant status, threatening to disclose immigrant status of anyone in the unit or anyone associated with the tenant in an attempt to induce tenants to move out. So this would apply to tenants who know tenants who might be vulnerable, like maybe it's a legal immigrant who knows undocumented immigrants or have family members, and the landlord has learned about this and he wants to extort using that information. A third prohibition, threatening to report immigration status in retaliation for a complaint. Number 4, evicting based on anyone's immigration status. And so that is now a new defense for evictions in our unlawful detainer, in the state unlawful detainer law. And then last, reporting tenants' suspected immigration status. Landlords were doing this to get immigrants out of units, especially rent-controlled units, so that they could raise the rents to the market rate. So this law can be enforced by the tenants themselves. The legislature recognized that a lot of these tenants are not going to want to file a lawsuit, so they create a special standing for nonprofits so that nonprofits can file these types of cases on behalf of tenants. Here in Santa Monica, we are going to enforce this law through our tenant harassment ordinance. That's at least one way we can do it. Our harassment ordinance incorporates all fair housing laws and prohibits landlords from violating fair housing laws in harassment campaigns or conduct. And so we can incorporate this law and call it a violation of our harassment ordinance. And we actually have our first case right now that we are investigating on that basis. Okay, so I'm going to move on now we're taking questions at the end, right? So I'm going to go to the school year evictions ordinance that our city council passed back in May. It went into effect in June. And the story behind that is that we were seeing in our office, and we checked with the rent control board staff and legal aid, and they were all telling us that there were no fault evictions happening in Santa Monica of families with kids that were still in school during the school year. And that was coupled with some studies that had come out that said that such evictions are very harmful to kids' education. And it's not just the short term. It's not just the trauma of getting pulled out of your home in Santa Monica and then your school, because most families cannot afford to move into another Santa Monica home on that short notice in the middle of the school year. So they often end up in different school districts. But that it actually, when the studies looked at standardized testing results, it affected, those kids were getting lower scores across the board. And the city of San Francisco, they acted first. They passed a law that prohibited no-fault evictions during the school year of students and teachers. And that went through the appellate courts. The appellate courts determined that our unlawful detainer statute does not preempt this type of law. And so our council immediately passed a very similar law. And so I'm going to read off and I forgot to, actually, let me give you a good example from Santa Monica. We had, before this law went into effect, we had a single mom come to us. Her daughter, the daughter's name was Audrey, was in the 3rd grade in Santa Monica. She had pretty serious learning disabilities, so she had a plan for that in her school here in Santa Monica. This was right as the school year was about to begin. So they had already worked up a plan, and they'd been working with her counselors and her teachers, and so she was all set for this school that she had attended for the last couple of years, where everybody knew her, and then she gets this. Her mom gets this eviction notice where she was going to have to leave in October, right? Just a couple of months after the school year begins. So that's the type of student that this law protects, because especially for kids with disabilities, they being uprooted from their school is very harmful to their education and their rights for disability plans. So this is from our ordinance. A child under the age of 18, or any educator, if you have either those two in the household, that's a requirement for this law to kick in. The child or educator is a tenant in the unit. The tenant has resided in the unit for 12 months or more. The effective date of the notice of termination falls during the school year, and the termination does not allege any fault of the tenant, but is based on the owner's intent to occupy, demolish, or withdraw the unit from the rental market. Now, I'm going to just add, even though we're going to have questions at the end, our most frequent question is about the timing of the notice. So we've had questions from owners saying, I gave the notice before the school year began. Well, that doesn't matter. What matters under our law is when the notice expires and and the eviction can begin. So even though you give a tenant a notice, a month before the school year begins, what you look at is when the notice expires. Same way with the very end of the process. A landlord can give a tenant a notice during the school year as long as that notice expires after the school year ends. And we'll take more questions on that if you have them at the very end. So the last thing I'll cover is that update I told you about. Under our Fair Housing Ordinance, which we amended, landlords cannot discriminate against tenants on the basis of their Section 8 status. And that we've made that very express in our law, because the city was in the middle of our affordable housing crisis, was seeing a lot of landlords saying no to Section 8 voucher holders. And it was happening in two different areas. You have the applicant who is looking for new housing, and they're going around asking landlords, they're otherwise qualified, and they're asking landlords to accept their Section 8 voucher, and the landlord can just say no to that, and he doesn't have to rent to that person. The other situation is where an existing tenant who's lived there for several years, sometimes many years, and they're barely making it because they're paying. We've had a couple of cases where tenants are paying up to 90% of their income for housing. So that tenant desperately needs this voucher just to be able to keep their home, and they say to their landlord, I've got great news, I've got a Section 8 voucher, I'm going to be able to pay the rent every month now, and the landlord says, no, I don't want to deal with the Section 8 program. So that was happening on a rampant basis, and the city council ended that with this new law back in 2015. Now we were challenged by the Apartment Owners Association of Greater Los Angeles in court. They sued to stop this law from going into effect, and so we were in court for a while over that. We won with the help of the Legal Aid Foundation, and then it went to the appellate courts for a while, and finally this April, the AGLA, the Apartment Owners Association, dismissed that appeal. And since we've been enforcing that in earnest since that point in time, we have helped 10 tenants who had been told in writing no based on their Section 8. We've helped them change their owners' minds, and now those tenants all have housing with their Section 8 voucher. So we're seeing a lot of success in that program. The stories from those 10 are just amazing. The demographics are from all ages, all races. We've had folks with severe disabilities who were paying up to 90% of their income for housing, and they were on the verge of being homeless. And thanks to this law and the work of our office and the Housing Authority and the Legal Aid Foundation, the three of us work on each of these 10 cases pretty furiously to not only to get the landlord to change their mind, but actually help the landlord walk through the process of getting signed up with Section 8. So on that, I will stop there, and we can, I guess, all take questions. Thanks, everybody. First question.
Yeah, and just thanks, Gary. Excuse me. One more thing I just want to say about what we do at the City Attorney's Office. We work with everybody who has questions or problems related to these local laws and landlord-tenant disputes. We get calls from many different owners, property managers, subtenants, tenants, people all over the spectrum, and we always appreciate the turnout here. I know there are a lot of folks here who work on management or ownership of property, and not just renters. But we encourage everybody to give us a call at the City Attorney's Office. Check out our website. If we can't help you directly or try to answer your question about the law, we can try to refer you to somebody who does. We can't represent people directly, of course. We are not private attorneys. But we do try to help clarify the law, and there's been many a phone call that we've all had among the staff of our office where we're able to clarify things. And we find that most property owners want to do the right thing. Certainly you folks that are here today to find out what some of the rules are, we appreciate that. And we really do try to all work together. So we appreciate you coming out. We're going to try to answer your questions. And Mr. Stern, you've been very patient. You can go first.
I've been a tenant of Santa Monica since 1986. At the time, I was the first tenant in the complex, and it was owned by the city of Santa Monica. In 1987, a year later, the city gave management of the property to the county of Los Angeles. The county has made since then untenable. They've been tried to be 5 times for not stupid. There was no reason for it except harassment. And basically, they just recently had a meeting in El Monte or something. That's where their office is. How can a person, a tenant, I have no say there. They don't listen to the tenants because they could care less. I spoke with the supervisor of this area.
Sure. Well, that's a good question and a good example of something that we can address. And of course, you have talked to our office many times over the years, and one of the ground rules for today is that we're not going to be able to go into people's individual situations and give you, kind of direct counseling on your situation. We're here more to talk about generally what the laws and rules. What I will say, a tenant who's in a situation where they feel helpless or they feel confused or that they're being harassed or the owners aren't following the law, there's an eviction coming up, they don't know what to do, pick up the phone, call one of our offices. You can call Rent Control, you can call the city attorney's office, and whoever answers the phone is well-trained and well-equipped to try to answer your question or direct you to somebody else who can. Today here, unfortunately, we're not going to be able to go into your individual case.
I was on TV, the city council or the Rent Control board. I spoke of the exact problem, and then 2 of the board members of the Rent Control said they would get right back to me. Never happened. That was 3 months ago. And then when I love, they're very nice people, but I'm not there's no enforcement of what's going on.
Okay, well, we should talk separately about your situation, because it's,
But there's 22 units, and everyone feels threatened, so no one complains except me.
all right, well, thank you for your question. Yes, ma'am.
I'd like to encourage the last thing you said in writing about refusing you if you have a voucher. Would that count in an email if they said the owner for this property refuses to accept a voucher?
Oh, definitely. And I emphasized in writing not to say that that's a requirement under the law. If a landlord said,
I mean, I've heard it verbally.
yeah, verbally is prohibited as well. We just happen to have a string of cases where it was actually in writing, so that just showed, early determination by the landlord to not get involved with this, and we were able to change their minds with this new law. But it does not have to be in writing; it can be verbal.
Yeah, because I usually look at the rents, and if the rent is in that's where I go. And
Right.
if they're in that, which is very rare, and then they refer, they say, no, we won't accept that, it's really confusing for a person, especially when I've undergone 6 years of tenant harassment, and I have files on it, pictures on it, and now that they got me out temporarily, they're trying to buy me out with $15,000, and it's like, I don't think I can legally even accept any buyouts because of the tenant program.
Right. So your example shows that if they are not wanting to participate in the Section 8 program, some landlords won't say that. They won't write it. They won't even say it. And so we have to sort out whether that's what's going on. And so if you report to us that you felt like you were otherwise qualified, and that the rent amount penciled out with a Section 8 voucher, then we will look into it. We will see if we can see from the pattern or from conversations.
Because you're with the city attorney.
Yeah, we're both in the Consumer Protection Division at the City Attorney's Office.
Okay, so you're not with the Daily Press personally, just you write an article.
Right. We have a monthly
That's
column.
a question because I'm meeting with Madeline a little later today about this whole situation.
Okay.
So
Yes, Denise.
I'm from the Legal Aid Foundation. So if anyone has an issue like that where their landlord is refusing, the prospective landlord or current landlord is refusing a voucher and within the payment standard for Section 8 or something, you can call our office, and we'll also be able to help you if you qualify. We'll give you advice or see what we can do. But I always advise people to make sure they get it in writing if possible when they go to a property and they ask and the landlord says, I don't take Section 8, and try to get it in writing if you can, or bring a witness with you. Because having documentary evidence is a good thing. It's not critical, but it really helps. So.
Yes, ma'am. Oh, okay. Will do. Yes, okay.
I'm wondering how much of this, I'm an owner, I own a trailer, it's rent control, but the leases cost CPI, but I pay rent control in the state. So how much would this apply to me? A lot of stuff is happening in traffic.
How much of
What you're talking about?
like
As an owner.
like the Section 8 ordinance?
No. I own the trailer, so, and it's rent controlled.
You rent the space.
Yeah.
Rent the trailer.
Yes.
Right.
How's the trailer rents the space? How does it apply to her?
Yeah. Well,
Could you paraphrase, because we can't hear the.
yeah. The question: she owns a trailer and rents a space for the trailer here in Santa Monica. So if you were to rent out the trailer, then it would apply. You're being harassed by the person who owns your space.
That owns the space.
No, I mean,
Insurance company,
tenants, some of the tenants continue to harass me and the management guy constantly, and it's 3 years now.
Your tenants are harassing you.
Yeah, some of the tenants there.
Okay.
I
So
think what she means is she lives in a park, a
The
mobile
29 call it
Yeah.
out.
and she owns the trailer, it's on the space, somebody in the park manages the park
There's a management company
that is harassing her, and other tenants are harassing her.
The
She's a
tenants,
tenant of the space.
Okay, so her question is, in that circumstance, do the laws that we just talked about apply? And they do. They are, the definition of landlord is pretty broad. The definition of tenant is pretty broad in our ordinance. Tenant harassment of landlords is not covered in our ordinance. I think I caught that, but that's not covered. And I don't know about rent control. Do you want to add any rent control?
Rent control
aspects of that?
does apply in a complicated way to mobile home pads because the pads are controlled. You do own the trailer, but the pads themselves are controlled. So depending on what the situation is, you can definitely call us and we can work through that and see if there's anything that would apply for that. But for the tenant harassment ordinance, you talk to the city attorney's office.
Yes, ma'am.
So our apartment complex has been sold a number of years ago, and we believe that they're going to either flatten the place or take place out or something. It's exactly the example that you were talking about. And so I contacted the city to find out if they've applied for Ellis Act. They have not. My understanding is that they have to apply a year in advance, or about a year in advance. And then another question is there any other way that I can check to see if they are trying to get permits for construction or trying to do anything with the property?
So it doesn't have to be a year in advance. I'm sorry. I'll repeat the question. So she said her property the building where she lives was recently sold, and that there are rumors that the building's going to be demolished, and there's rumors about the Ellis Act, and she was wondering if you have to apply for the Ellis Act at least a year in advance, or if there's another way to find out if permits have been pulled with regards to any construction for the building. So the Ellis Act takes it can take 120 days or it can take a year depending on the demographics of the tenants in the unit. So if you are 62 or over, if you are a tenant in the unit is 62 or over or disabled, then you can stay for a year once the Ellis Act has been filed. If you don't qualify under those two categories, then the notice period is 120 days. So basically a landlord you would find out very quickly if an Ellis Act has been filed because they've filed with the county, they file with us, and then they have to tell the tenants within 5 days. So it all happens in a very short period of time. So calling us to ask, hey, has this been filed? That you can definitely do that, or you'll know fairly quickly once after we know. The other thing is if you want to know if permits have been pulled, you can definitely call planning and building and safety. They can let you know whether or not things have been pulled. And the city actually has a new project where if we're seeing that a lot of permits are being pulled at one building, there is a city staff member who's keeping an eye on those properties where there's a lot of construction work that seems to be coming down the pipeline. And so the city is going to pay more attention to those buildings where we're seeing lots of permits being built or being pulled. But the Ellis Act, you'd receive at least 120 days notice. You will get something in writing. A landlord does have to pay relocation. The permanent relocation fee is based on, it starts with the number of bedrooms in the unit, and then it goes up depending on the demographics of the tenants. Okay. Are you gonna?
Sure. I'm going to give you the microphone, Denise.
This is critical for people. So it's really important to get legal advice about whether or not you want to accept a buyout, because if you are a low-income person, you may qualify for especially qualify for affordable housing in the city, but you have to actually have the notice, like an owner occupancy notice or an Ellis notice. It can't just be, I signed a buyout agreement. So before you sign anything, you should come and get legal advice from legal aid if you qualify, or from another attorney, because there are some sort of benefits to, waiting for the Ellis notice, and people wouldn't know that unless they got legal advice.
Thank you very much. All right. Yes, sir.
Hi, yeah. This is a question about owner occupancy. If the new owner of a building is sold and a new owner comes in, and says, we want your apartment for somebody in the family or for myself. I was told, and I want to know anecdotally if it's true or not, does that have to be an actual person? If the building is bought by an LLC or a corporation, can they then say, I want to use your apartment? Or does it have to be old school, Mr. and Mrs. Smith bought the building, and it's not an LLC or corporation? In order to get the eviction, yeah, how's that work?
So in order to evict for owner occupancy, can you evict for owner occupancy if the owner is not a natural person, was the question. So in order to evict for owner occupancy, the owner has to be a natural person. It can't be an LLC, it can't be a corporation. An owner has to have at least a 50% interest in the property. And there's requirements about what units they can actually evict from. So if you do get an eviction notice, definitely call rent control, and we can sort of work through what all of those requirements are. But yes, the basics are it has to be a natural person, and they have to have at least a 50% interest.
And how far down the family can it be? Can it be a fifth cousin or?
There are so an owner can't evict for the fifth cousin. There are enumerated relatives that are specified out in the law. It's I probably won't cover all of them, but it's the basics that you would think. It would be your siblings, your parents, your children. I think sons and daughters-in-law are covered. Not first cousins, yeah.
But can the LLC then find somebody?
No, because the owner has to be a natural person. In order to, even if they're evicting for an enumerated relative, the owner has to be a natural person. Okay.
It's funny, I just started reading a book about these scientists who are tracing the human family tree, and they have something like 500 million people already placed in the tree, and so we're all related. So you could have a lot of abuse of the law if you were to carry to that extreme. Yes, ma'am.
Yes, I have a question. If you live in the house by yourself, you have health issues, is it lawful for a person to have a relative have a key to your apartment so they can check up on you?
The question is whether if you live alone and have health issues, whether it's lawful to have a relative who has a key who can come over and check up on you. I don't know of any problem with that. Sure. Absolutely. I mean, the one issue that sometimes arises is where an owner might claim that someone else is residing in the unit, living there. And even then, there are allowances for home health care workers if they're necessary, or folks that are hired who are of medical need. But that's not even what you're talking about. You're just talking about somebody coming by. I don't know of any problem with that.
I would just add that if the health issues are a disability that a doctor can diagnose as a disability, then if there's, say for example, if the landlord happens to have a rule that says only tenants can have keys, they would have to make an accommodation for the tenant who needs someone to check up on them. And like Adam said, there's definitely caregiver exemptions built into the fair housing laws, but any accommodation that you need as a person with a disability would have to be looked at and accepted.
Okay, thank you. So in other words, it's no big deal if they have a key to come in and check up on someone? No big deal.
It should not be a big deal.
Yeah. Yes.
Can you talk about Airbnb a little bit, and to what extent the management board gets involved into cases where there is or Airbnb on the property, but the tenant's not willing to speak up?
Okay, a very timely question about Airbnb and when rent control can get involved, and if tenants in the building don't want to come forward and speak up. As many of you know, the city did pass a relatively new law that regulates the renting of rooms. One of the main requirements is that you cannot rent out a bed or room or space unless you live there in the unit. That is one of the main requirements. Marina, did you want to address rent control's sort of perspective on this, or does anyone else from the rent control want to address that just for general information? Briefly. Yeah.
So with rent control doesn't say whether or not you can Airbnb. Airbnb, the ordinance that regulates it, the short-term, how that is not part of the rent control's regulations. We always tell people that just because there's an ordinance that says that you can, doesn't mean that you may be allowed to. If your lease says no subletters, if your lease says no other occupants, you may be violating your lease if you start Airbnb. Airbnb, if you see that there are tenants in the building who are Airbnb and maybe violating the ordinance in some way, tenants or anyone who sees it can definitely call code enforcement, because code enforcement is who would come by or do some investigation about whether or not it's actually happening, and then they may take steps. But with regards to rent control, our laws don't specifically apply to this ordinance.
The one other thing that we've seen that comes up a lot with these sort of subdividing of units and renting out of spaces is the maximum allowable rent, or the MAR, because the rent control law still applies in a rent-controlled unit, no matter how many different people may be renting out a bed. So there may be people who are going on Airbnb and charging $1,000 a month, some small part of a unit, but you can't go over the maximum allowable rent regardless of how it's done. Is that right?
That's right. And tenants who are Airbnb should always keep in mind that the eviction protections also extend to your Airbnbers. So if they decide to stay, you're running that risk of having somebody just overstay their welcome, overstay their time there, and you would then have to take the same actions that a landlord would have to take in order to evict this tenant, and you would have to have just cause the same way that a landlord would have to have just cause, because you've now made yourself a landlord in this situation.
So in this case, in this particular case, we're not talking about the tenant. This would not be a tenant doing Airbnb, this would be a landlord or a manager. So how does that work? Because obviously the tenants in the building are not gonna come up and speak out because,
Well, you could always call code enforcement.
that was
Tenants would call.
code enforcement came and knocked on the door a couple of times and then left and then never came back. So how many times do we go on and call code enforcement? Which, there's not much they can do. Obviously, a lot of times Airbnbers come, they go during the day and visit the city and come back late at night, and code enforcement comes during the day, knocks on the door, and nobody's there, and they go back, and then they keep going like this.
So she's clarifying that this is the property owner who is using Airbnb, and that the tenants are a little bit not happy about people coming and going at all hours and a lot of the stuff you hear. And I think maybe one of the short answers to that is that there's nothing necessarily illegal about the owners using Airbnb. If they're following the city's law and paying the proper taxes and so forth, and if they qualify.
If I understand well, if someone, it's a rent control unit, so someone should live on the property, right? And have guests come for up to 31 days. That's not at all what's happening here. Somebody's on the lease, he doesn't live there.
Okay, you're talking about people who are not following the law. Right, if the person doesn't live there, right. Well then, all like Marina said, our code enforcement division, which by the way, for those of you who have not been here a long time, that division has grown considerably. They're much more staffed and strong and active than ever before, and they mean business. And so if you have problems with code enforcement, such as Airbnb violations, call them, because they get things done. So that's all we can really tell you is if there's violations of the law, please let City Hall know about it.
Tenants have to get involved and put their names down, and complain officially, pretty much.
Well, that's a fair. The question is whether can people be anonymous. Right. Tenants are worried about retaliation if they come forward. That's a valid concern. And I can't speak for exactly how they handle complaints. We always like people who bring complaints to come forward and give evidence and say who they are. But anonymous tips, I can't promise that that's going to get it done. I just don't know for sure. You should call them and ask. Yes, sir.
Could you discuss the parameters in which a landlord could petition for increases based on light improvements, not construction, but like over the course of the last 2 years, there's been somebody doing touch-up paint at least 100 days, and we have like groundskeeper, and we don't have any grounds. I was wondering, is a shoe gonna fall and I'm gonna see increases?
So the question is whether an owner can apply for increases based on more minor maintenance and repairs. Do you want to address that?
For minor repairs and things like that, the answer is no. There is an increased petition that owners can file with the Rent Control Board to try to get the rents increased. It's a very complicated petition, and it basically you're looking at major work, things, and I'm not going to get into all the details of it, but for things like minor touch-up or having somebody come around, that's not going to get an increased petition granted. If you have more questions want to get into the details of that, you can definitely call us and ask, but it's a very complicated one, and we don't grant them that often. Okay.
So don't worry too much. Yeah. Anybody else? Yes.
A question about when you're temporarily relocated into a motel or something, I guess there's some sort of code or something that you have to check out for 1 day somewhere after 4 weeks of stay and check back in, otherwise supposedly the place is in violation. Is there any exemptions when you're disabled and temporarily being housed in such that override that 1 day rule?
The question is about temporary relocation where a tenant is placed into a hotel or motel temporarily while work is being done or their unit is being fixed up. And she's asking about the well-known 30-day rule about if you're in a hotel for too long, it can be considered a tenancy, so they like to move people out and back in. That's a fairly complicated area of law. It is true that sometimes tenancy rights can arise if a person stays a long time. We have what I hope is a helpful breakdown of it on our website, smconsumer.org. smconsumer.org is the city attorney's consumer website where we do talk about the 30-day rule. It is somewhat complicated, but the short answer to your situation is that if you need to be relocated by the owner, they need to provide you with temporary housing. If it goes more than 30 days, they're supposed to get you an apartment. Okay, that's what the law says. If it sort of barely gets to 30 days eventually and it wasn't expected to, it's not always treated that way. The city has a coordinator who's a large part of her job is dealing with these exact situations of temporary relocation. I don't know if we have her extension handy, Ide's number.
I just heard that.
Ida Gonzalez is her name. She is, I believe, works with the Code Enforcement Division, but she personally handles these kind of questions and problems.
Voicemail of the code compliance put me through to, but I haven't heard back from her. So.
Call her again. Okay. Yes. I'm sorry. Yes, the gentleman in the back. Yes. Yes.
Hi. So I have a two-part question, and it's going to come across as off-center, but I have a rationale for asking it. The first is, what % of your clients at the city attorney's office are tenants?
Okay, well, we don't have clients who are residents of, our client is the city, okay? We give out information and we enforce the law and we bring cases for violations of the law. And I think what you're getting at is, do we more have cases on behalf of tenants as opposed to owners? It's no secret that the laws we enforce are tenant protection laws in the consumer division, okay? The information we give out, events such as this, phone calls we answer, and even cases we bring are not representing one side or the other. If we see violations of the law, we try to do something about it. And so, yeah, most of the legal action we bring is involving situations where a tenant says that somebody broke the law and violated their rights, okay? I don't have the exact percentage for you, but the overwhelming majority of legal cases involve violations of tenants' rights while we're talking about this area.
And then the second part of the question is, are landlords freely able to consult with the city attorney with any matters that directly or indirectly impact tenancy laws?
And so the second question was whether landlords can consult with our office about laws that may impact their landlord-tenant relations. And the answer is really the same for both sides of the aisle, that we don't consult directly with people's situations and tell someone what to do or give someone their odds or counsel them. What we do is talk about our interpretation of the law and what's required. So we get calls all the time from owners who say, hey, I want to owner occupy. How do I do it? Who do I call? Or, my nephew wants to do this, or I need to relocate my tenants. What kind of, how much money do I need to pay? We get any number of questions on how the law affects owners, and we do answer those. We don't counsel people directly. If you want to get direct legal advice, if you're lucky enough to qualify for legal aid, if you're a tenant facing eviction, something like that, they can certainly help. But most of the time, you're going to need to get a private attorney if you want someone to represent you in a dispute or to give you advice on, this is what you should do. We're not equipped to give direct advice to people. We're just not allowed to do that to anybody. Sure. Yes.
Yeah, I might deviate slightly. I've had some issues with not service animals, but comfort animals. And I called Gary, and Gary returned my call. He might not have given me legal advice, but he did two things. He promptly responded and gave me information which enabled me on my own to make a proper decision and helped me better understand my options. Maybe not legal advice, but neighbor to neighbor, he gave me excellent advice. City Attorney's Office in Santa Monica has historically been available without reservation, unvarnished, to give people that provide housing excellent advice to avoid pitfalls and difficulties. Adam and Gary have always been champions of helping people avoid problems. So the answer is pick up.
Thank you, Michael.
That's what's known as a softball. Thank you, Michael. Yes.
I have actually asked the same question in the previous meeting that we had, but I haven't got any, how would I say, concrete answer. I'm disabled due to my heart problem and artery problems and all that. And I live in a situation where the tenant under me who have moved in last year, he's an attorney himself. And he admits that he knows the city law, but he ignores it totally and he smokes left and right with his guests, marijuana, you name it. Whatever it is, they smoke it. I'm inhaling all these hazardous chemical things coming into my apartment and making my, making my condition worse day by day. I have told the landlord, I have confronted this man and been telling them that this is the situation. My doctors have certified my my health condition I have sent it to the landlord and etc. But nothing happens. In other words, this man continues doing whatever he does, slapping back into the city attorney's office and laws and what have you, and ignoring the entire situation without any respect for anything. So, as I mentioned, I'm disabled. And I don't, how would I say, I'm being kind and a gentleman in reality to give the opportunity both to my landlord and this tenant to quit or do something about it. What I'm asking basically is this. who wrote this law when it comes to the smoking? It's basically a scam in total ways that you can mention.
Have you called the
There
police?
is no, I'm sorry, what?
Have you called the police? If he gets a ticket, he gets a $500 fine.
I have called the police. Police doesn't know a bit of the law. They're arguing with me that he could actually smoke in his balcony or inside his apartment.
Okay, that's a very good question. And
So my question basically is two. Whatever this man does and whatever my landlord do, is it based on the harassment due to my situation, to continuing doing that? Or whoever has been writing this law, I mean, you gotta be ashamed of themselves. This law basically killing people around you. And the history and outside of whatever it is. And if the city attorney is unable to do anything about it, then who is it? Who is?
Okay, it's a very good question, and I appreciate that. We haven't talked about smoking yet today. The gentleman's question is that he has a disability and a heart condition, and there's a nearby tenant who smokes tobacco as well as marijuana, I believe both, you're saying, and it's causing a lot of health problems. And you want to know what your recourse is, what your rights are. And one of the gentlemen a moment ago suggested call the police. That's actually not what is going to be helpful here. But I want to address that. And you're expressing frustration with the law, how it has so many limitations where there may not be anything you can directly do about this. So I want to start by just clarifying one thing. There's things you can do under the law about smoking, and there are other things, okay? We get a lot of questions, mostly from owners, but also a lot from tenants about, what does the law do? How come these people can get away with smoking? So one of the first questions is how long you say it's an attorney who lives in this other unit who's been smoking.
Since day one when he moved in.
Okay, and when did he move in?
He moved in last year.
Okay, last year. So anybody who moved in last year, that's well after the cutoff date of being grandfathered in and it's November 22nd. I apologize. I don't remember offhand exactly what years. 5 or so years ago? Does anyone remember the exact year? 2012, 6 years ago. November 22nd, 2012. Anybody who moved in after that date, by law in Santa Monica, their unit is considered a non-smoking unit. That's condos. It's not just rentals. It's any multi-unit property. If you move in after November of 2012, you cannot smoke in your unit. The problem is, as you recognize, there are big limitations on how that law is enforced. Now, in theory, any private person, whether it be a neighbor, a landlord, a person walking down the street, a random stranger, could go to court to enforce that, and there is a $500 fine for the person. Difficult to enforce. Yes, I'm sorry. Sorry, $100. It escalates. Sorry, starts at $100. Thank you. But yeah, that's not a very.
With the $2,000, but the question is, I understand where you're going, but what I want to know is, if the guy go to the small claim court and sue him for $2,000, okay, I get the $2,000 from him, but he continues to smoke in his apartment. What good does it make? I'm not interested in making any money out of this situation. I'm interested in living long enough
You're
to
saying
see
the
my
money
grandkids
is
grow
not
up.
a very big inducement. Right. It's not a perfect remedy. And the main thing I can tell you about your frustration with the law is that the city council is weighing various policies, and they debated very heavily when they enacted these smoking laws. There are a lot of other areas besides just Santa Monica's law. Now, Santa Monica has a very limited law that provides for units that are either smoking or non-smoking units. Common areas you cannot smoke. So if there are common areas in the front or back of the property or balconies, you cannot smoke in those areas anyway. The only area where we're even debating is inside the units, where it may go up through and affect other units. So as Denise says, if you have a disability, you may have disability rights where the landlord has to accommodate your disability by taking that into account and how they deal with the other tenants. there's also, even more broadly, there are issues that private attorneys, we can't do this, but private attorneys are increasingly looking at cases on behalf of owners and potentially co-tenants for health issues, potential things such as nuisance. Now, I'm not saying one way or the other that any individual case is a good case or a bad case. What I'm saying is that smoking, secondhand smoke, and now even thirdhand smoke are so far beyond documented as having no safe levels, extremely dangerous for all people, especially some people with particular conditions, that there are various legal rights, okay? We have a very limited set of laws that we can tell you about and that we can help you understand and enforce in Santa Monica, but that's not necessarily the end of it. And so one thing that our office does do, that our staff is very experienced in, is dealing with disability issues, okay? Reasonable accommodations by owners of their tenants' disabilities. And so that's a very good point that, if you have a documented disability and anything going on the property is affecting it in a serious way that the owner has the power to maybe accommodate, they at least have to look at that and come up with a reasonable solution. And our office, thanks in part to Gary's longtime expertise in the fair housing cases, we look at those situations and we roll up our sleeves and sit down with the owners and try to work it out.
Mr. Gary, you got my files last time we met, which was about 6 or 7 months ago, or more than that. I gave you the files written by my doctors, my medical condition, et cetera, and et cetera. What happened to it, I have no idea. Nobody contacted me from your office. The same situation is now. I'm looking for an attorney to take my case and bring it up into either the court or the small claim. I don't have the opportunity to do that by myself. I cannot go through all the process to do such as suing things and etc. I only have the documents, and I'll be happy to provide it to you by any means or any way you want to. The rest of it to me is just
Okay, thank you. Yeah, we're not going into individual cases, but we're trying to provide you with general information. Are there any other questions about any topic related to landlord-tenant? Yes, in the back.
Can you explain the legality or illegality of a landlord, the owner of a property takes and makes a tenant in a unit, say 6 units. He's now the on-site property manager. Gives him all the keys to the entire property. He's not licensed. He causes problem for people. He is then enlisted to harass the tenant of a rent-controlled property on the same property. And what are the legalities of that?
The question is a 6-unit property where there's an alleged property manager who has keys to all the units, and you're saying if the owner is having them go and harass the tenants, what's the legality? Well, as I said earlier, a manager or any other kind of representative, even an informal representative, is very much on the hook for violating that law, as is the owner who puts them up to it, if that's what's going on. So if this person is entering units improperly, but you mentioned the keys, so I assume there's something to do with entry. If they are approaching tenants in an improper way, that's potentially illegal.
Also, them employing other members of or tenants in the same building to execute the same kind of harassment as well.
Right.
Is that something where it's
happens.
like he's separating, the owner of the property, is he separating himself legally by one layer of separation because he's a tenant and now I can't go after him because he's doing that? Or is he still liable because this individual is working under employ of this individual in that capacity?
The question is whether an owner can insulate themselves by having others do the bad deeds, such as fellow tenants. And the answer is absolutely not. No. Those other people become landlords, as we say, but the landlord themselves is also very much on the hook. Sometimes those cases can be hard to prove that someone is doing something because they were put up to it, but you'd be surprised. People are sloppy sometimes. And there's also what's called circumstantial evidence, if it looks pretty obvious what's going on. So we would encourage you, if you believe that people are being harassed and their lives are being made miserable and the law is violated, please give us a call. Okay. Yes.
So on that same note, tenant harassment and the same kind of situation here, again, just want to be clear about how does that work? Do the tenants have to come forward and give their names and become basically witnesses to what's happening? And even if their safety is really threatened and they feel unsafe by doing so. So how do we go about that? Because that's a real fear.
Very good question. The question is whether the tenants have to come forward and be identified, be witnesses in order to get something done. And the answer is it really depends. We encourage that. It's the more you come forward, the more we can do. We do, let me just finish the answer. We do get anonymous complaints sometimes where no one ever tells us who they are. Sometimes people come forward and say, hey, there's this stuff going on, but please don't give them my name and because I don't want to get retaliation. We get the whole spectrum. And the more you work with us, the more we can do. And sometimes it is scary. We encourage people, especially on some of the worst behavior, that, look, for us to really do something legal, we need a case we can bring to court if it's that kind of a case, if it's serious misconduct. We can't just go and say, hey, there's rumors and allegations. On the other hand, once in a while, there are some things that can be proven with an anonymous tip. It's just behavior that they want us to know about. And we don't discourage that. If all we're going to get is an anonymous tip, we would rather have that than nothing. But I'm just going to say it makes it very limited what we can do.
Have you guys used the ring bell, the doorbell, whatever, the video?
We've heard about those video doorbells. We haven't used them ourselves for cases. They've come up in some of the cases we've investigated, though, and let's just say they do provide interesting evidence sometimes too much information. Yes, sir.
Relating to that, say you had a tenant harass you, you've gone down and you've gotten a restraining order because that you could not prove that he was guilty of stealing icons. Straight up, the guy was known to the tenant, being the only witnesses in Hanford. The man looked at us and we went and got a restraining order. He chased us down to, after we served $50 figures. He's harassing us. They have not, we don't know who to call to enforce the restraining order. No legal seemed to do it. He has broken the law repeatedly. He came home that day and did what he wasn't supposed to do.
Okay, the question is, there's a restraining order against the owner?
No, a tenant, a fellow tenant.
Oh, against a fellow tenant for stealing and so forth. And the question is, how do you enforce a restraining order if you're afraid for your safety? I mean, technically, the police, if it's a sign.
They called the landlord. We called the landlord, and he said call the police.
Okay. Legally speaking, if you have a restraining order, that means it's signed by a judge, and a person who violates it is in contempt of court, and it is something that the police can investigate. I'm not saying in every case.
Not the marshal, not the sheriff, just the police. I mean, we've tried all three.
Yeah. Well, it certainly could be reported to the landlord as well. I mean, but yeah. I'm not sure what to tell you on the best road there. I mean, violating a restraining order is serious business. It's potentially a crime.
The guy came over, and she said he's supposed to park in his space and always parks in hers.
Yeah.
And he came home from court a minute after that and parked it in
yeah. I would say problems with fellow tenants is some of the toughest problems that we see. And, we can't really get involved in those situations because normally it's either a police situation or...
Who do I call? Because I called the police and they said, no, we can't do anything about it.
If you talk to the sheriff and the police about the violating of the order, then, I don't know what else to tell you if it's a private restraining order.
Well, the police should cover it, but you can also go back to the judge, back to the court, and let them know that they're violating his or her order.
Yeah, it's actually a very good idea. Judges are never happy when their orders are ignored, and they might have some ideas on dealing with the police. Mr. Stern, is it on something different? Okay.
Can the city transfer the property to the county's management without tenant participation?
Okay, the question is, and I believe you said on your property, it was owned by the city, they transferred it to the county without the tenants.
The building was transferred to the county. The property is still owned by the city.
Okay. As far as ownership of a property, I'm not aware of any laws that require tenants to be really even notified the one thing I will say is that under state law, when ownership changes and you have to pay your rent to a different person, they have to tell you about that. You have to be told where to pay rent to the new owner. But as far as being in on the transaction or part of that transfer, there's really nothing that requires tenants to be involved.
Speaking of the control of the property, I've been beaten twice by management, just been attacked and beaten, and yet, and no one wants to take responsibility for this management of the management.
Okay, well, one other thing I want to mention, you're talking about being beaten by members of management. Please remember, everybody, when we're talking about landlord-tenant issues and the different agencies, that if you ever are feeling in danger or if there's something violent going on, please call 911. Please call the police if there's actual attacks going on, and we've seen them. There's been some crazy stuff that happens in the landlord-tenant context, but please keep that in mind. We do need to keep moving. Yes, ma'am.
This question is probably for rent control. I just had a question regarding new construction and buyout / relocation. What are the landlord's responsibilities in regards to that?
What do you mean? Sorry.
As far as relocation for new construction, so we have like rent control buildings currently, and then we are going through the permit approval process with the city for new construction, so the building will eventually be demoed. And want to know what the parameters are for the current tenants of the building.
So you're saying there's a building in existence right now, it's a rent-controlled building, the ownership plans to demolish the building and put up something new?
Correct.
So,
and if they're going to be apartments eventually.
They're going to be apartments.
Want to know the parameters as to what
so
is required.
That's something where the Ellis Act would come into effect. So I talked about that earlier, where you've got the 120 days, or a tenant can get up to a year. You're asking about the relocation.
Yeah, so what does that include typically? Like, is it the landlord owner's responsibility to pay for the rent while new construction until the new apartments are built?
Are you thinking that the tenants are going to move back into the?
Because they're rent controlled, the units that are currently existing are going to be also in construction under rent control. So I believe we have to offer them a unit in the building. So I just want to know, during construction, are we also obligated, if they don't take the buyout, to pay for their rent or the same amount of their rent? How that works?
This is a little bit of, yeah, I think that we should probably talk about this, not on camera, because it gets a little bit complicated, and I think you're mixing up a few different issues. But there is temporary relocation, which sounds like you might be talking about. There is also permanent relocation. But those are two separate issues. And so we can talk, I have my business cards. We can talk about it here, or we can talk about it back at the office. Okay?
Okay. Yes.
Yes, for those who are long-term tenants in a rent-controlled situation, their rent is based on market values, which keep going up because of all the development in certain neighborhoods and so forth. So how often can their rents be raised? Because that pass-through thing doesn't apply to them, right?
So the question is, with rents going up, how does a landlord raise rents on a rent-controlled unit?
So long-term tenants, the ones that are pre-1999, their rents are actually not going up based on market. Their rents are controlled based on what was in effect on April 10th of 78. Since 1999, when a tenant voluntarily vacates a unit and a new tenant moves in, then a landlord does have the ability to renegotiate a new rent with that incoming tenant. And then once that incoming tenant's rent has been established, the increases are controlled afterwards. Increases take effect as early as September 1st of each year. And the increases for the last few years have been based on the Consumer Price Index. So generally speaking, tenants will receive notice in August, letting them know your rent increase is going to take effect September 1st, and this is what your new rent is going to be. And so there's always a little bit of confusion because a tenant's rent may not be just what the controlled amount that rent control controls is. It can be made up of three parts: the controlled rent, the half of the rent control registration fee, which currently is $8.25 a month, and then the certain property taxes if the landlord can pass them through. But it's not something where a landlord can come up to a tenant and say, well, you moved in 2 years ago and now market value has increased $300 on your unit, and so I'm going to pass that through to you. If you have been residing in your unit and you're under rent control, then your increases are controlled. So we tell the landlords how much they can raise the rent every year.
But it's just once a year they can do it.
It depends. So if you are not at what we call the maximum allowable rent, which is the controlled portion of the rent. We have tenants who have been living in their units for many, many years and maybe haven't received an increase in that time. So we recently have had a number of tenants who hadn't received increases in 10 years, and now they realize maybe the property has sold and a landlord is bringing them up to that new MAR. A landlord may do that in steps. So you may have a situation where over the course of the year, maybe 3 different times, a landlord gives you a notice increasing your rent because they're bringing you up to the controlled rent. But if you get multiple rent increases, that's not super common in a year. So you should definitely call us and we can check to see what is your actual controlled rent, how much can they raise it to. We also, throughout the year, send mailings to tenants with the MAR on the back of the newsletter, letting you know this is your MAR. So if you're under that MAR, you should know, you should always keep in mind that at some point your landlord may raise you to that MAR plus those 2 other fees that I talked about. So that's something to always keep in mind. If you haven't received an increase in a while, you may receive one or you may receive a few just to bring you up to that MAR. Okay.
Is everybody in charge of the same kind of topic? Is everybody in the building, even though some tenants have been there pre-1999 and others post-1999, or is every tenant in the building eligible for the landlord for that increase or that same increase, or only those who have been in the building since 1999?
So the question is, does everyone get the same, basically, does everyone get the same rent increase? So the rent increases are both percentages and dollar amount caps. So everyone, you'll see, we send a summer mailing and it'll tell you this year's increase was a 2.9% increase with a $60 cap. So depending on your rent, you may reach the cap. And depending on if you're under, I can't remember exactly what it was, 2,000 something this year, then you would get the 2.9% increase. So not everyone gets the same dollar amount, but it's the percentage, and then if it hits the cap, it's the cap.
And then a couple of years ago, it was nothing.
It goes up depending, yes, so the rent increases are tied to the Consumer Price Index. So it's a straight calculation, so it varies every year. So yes, last year was 2%, this year's 2.9%, and it just depends on basically inflation.
Okay. Yes.
It's my understanding, forgive me if I'm wrong, that the Ellis Act is when an owner is going out of the rental business. And so I recall when it went into effect, a lot of people were putting up condos, and so they were going out of the rental business and then either renovating the building or knocking down the building and then selling them as condos. Now with rents so high, there's less condos and it seems there's more very high rentals coming into Santa Monica. So if they Ellis the building and everybody has to leave, and then all of a sudden they say, oh, you know what, we're not going to do condos, we're actually going to do rentals at a very high level, or we're going to knock down the building and actually make it a rental building, not a condo. What is our recourse?
Okay, well, the question is about owners who say they're going out of business under the Ellis Act and then go back into business. It's an age-old problem in Santa Monica that we deal with a lot. And I can maybe give a quick comment, and then if the rent control wants to add. You know, the short answer is that they're not supposed to do that. The whole point of Ellising is you go out of business. It's a state law, and California state law does put limits on how that's enforced, okay? And the short answer is that there are different levels of violation depending on how long they wait before they do the re-renting, okay? And that's another thing that I believe we have on our website as well as the rent control website with some of the details of that. But I think if you have a situation that you think that's been violated and you want more information, call one of our offices. Or if you want to report it as a possible legal case, is to call either of our offices for more information. Does that sound like makes the most sense? I mean, it would take a while to break down the exact numbers, but there are penalties for going back into business too soon. And the longer the owner waits, the more things they're able to do. But the upshot of it is that, yes, they're supposed to go out of business. And if somebody turns right back around and never does go out of business, but just uses the exact same property and gets new tenants at a much higher rent, that's against the law. And I don't know if anything from rent control or otherwise on that.
In terms of the tenant being notified that is that a certified letter? Is that an email? I mean, what's the form that a person is notified that a owner or a new owner is effectuating the Ellis Act?
Okay, the question is, what's the format for notifying tenants about Ellising? And I know you talked a little bit about that.
So there is tenants are supposed to be notified if an owner is going back into the rental business. Rent control is supposed to be notified. And there is a notice of intent to re-rent that a landlord is supposed to file. And they are supposed to offer it back to the tenants, depending on a number of different time limits, but they are supposed to offer it back if the building is still, if it's the same building that's still there, to the evicted tenants. And then the evicted tenants have certain recourses if, depending on how long it's been since the property was Ellised.
And I'm asking also about the initial Ellis notification. How does that come down to the tenant?
So the initial Ellis, the initial notice of intent to withdraw accommodations, that's the title of the form, that comes to the tenants in paper. So notice issues themselves are actually governed by state law. So I'm not entirely clear on what constitutes valid notice. So I will.
The reason I'm asking is I could see a landlord doing the notification at City Hall, not actually sending it to the tenant, and then 6 or 8 months later saying, oh, you know, we actually did it 6 months ago,
So the concern is that we will be notified, rent control will be notified, but that the tenants themselves will not be notified about an Ellis Act. That isn't going to happen. So they have to notify us, and then we actually send out mailings to the tenants with a bunch of different forms, like the forms to extend the tenancy for the year if you qualify. So you would be notified. And if you get mailings from us and then you come to us and say, you know, a landlord hasn't notified us, that's definitely something that you should come to us about, because they are legally required to notify the tenant.
I'm just trying to figure out like when the clock starts ticking or could be reset on an Ellis situation, whether it's 120 days or whether it's a year. If their intent is to Ellis, but they don't actually file the paperwork, it starts when they actually file the paperwork.
It starts when they file the paperwork, yes. It's not just, oh, I thought about Ellising, and yes. Yeah. Okay.
It's also important to remember that if an owner files Ellis and doesn't do it right, and the paperwork is wrong, they didn't notify people right, the whole thing can start over, even if it did start initially, if it wasn't done right.
And that's something an attorney would monitor, or who would monitor whether the Ellis was filed correctly or done correctly?
You would contact rent control if you get anything, and then we would follow up on that.
The question is, who monitors the rules about Ellis filings? And the answer is rent control folks do. Yes?
What determines the amount of rent increase and the frequency in affordable housing?
The question is, what determines the amount of rent increase and the frequency in affordable housing?
So with regards to the rent increase, so if you're under rent control, your rent increase is based on the
Rent control, specifically, just in affordable housing. There must be some regulation of how frequently they can raise your rents and what percentage they can raise your
What's the
rents.
ceiling for that?
Well, if you're talking about like deed restricted units for affordable housing, sorry? Right, okay, so those are, most of those are based on what the tenant's income is. And so, sorry, Denise, you want to? Sure.
The city has inclusionary housing, about 1,000 or more units, and those units are at different income levels, 30%, 50%, 60%, 80%, whatever it is. So your income can't be higher than that percentage of area median income. So for example, let's say that's $50,000, you can make up to $50,000 to qualify for that income level, but you can't make more. And then the rent is calculated at a set level based on that income level as established by HUD in the city's formulas for calculating rents, and there's charts that are issued. So that's how the rents are established, and rent increases are done based on increases in area median income over time. So once a year, usually there's either it stays the same or it goes up. That's how it's been lately anyway. So that's how it is. Does that answer the question?
Are we talking about the community corporation?
No, not community corporation. Affordable housing, which is inclusionary units in market rate buildings. Certain number of units might be affordable, or the entire building might be affordable. And if you get into those units through the wait list or something, that's how your rent is calculated. It's not based like
I know
Section
how it's
8.
calculated, but if my income doesn't change, my rent keeps going up.
That's true.
Yes, and what determines how much it can go up? I'm already over 50%. It can go up how much and how often?
Unfortunately, in that program, the way it works, it's not based on your income. It's a set amount. Everyone who lives in that income level apartment, 30%, 50%, pays the same amount. It doesn't matter if your income goes up or down. It does matter if your income goes up, because eventually you might not qualify to be there anymore. But if your income goes down, unfortunately, there's nothing that you can do except try to petition the city or your landlord in that building to move you to a less expensive unit, if that's possible, and probably not very possible. Well, not impossible, but possible. I mean, I don't know anyone who's tried it, but it's just an idea.
Yes.
I was looking at the rent control website, and I noticed you have a classifieds available to landlords who have just registered their units and have possibly moved to a rent control and now they live. I saw, is there a ceiling on the rents for, let's say, a one-bedroom apartment or two? Because I saw a two-bedroom apartment on 9th Street across from Pono Burger, and I went and looked at the building. Very good. A two-bedroom apartment for $4,000, a little over. I'm sorry. Is there a ceiling? I mean,
So the question is there a ceiling on rents for incoming tenants? No, you don't. So, and if you need to apply to raise the rent. So, no, if a tenant moves out voluntarily, a landlord can negotiate a new rent with an incoming tenant. So if there's a tenant out there, and I know the rents have gotten pretty crazy in Santa Monica, but if there's a tenant out there who's willing to pay that amount, then yeah, that establishes a new, there's no maximum. State law prohibits, the maximum allowable rent applies during the life of the tenancy. So once a tenant has vacated voluntarily, then a landlord can, state law gives them the right to negotiate a new rent with that incoming new tenant. So that's how you are getting these pretty high rents.
Any other questions before we break? Yes, sir.
I've heard of apartment buildings being converted to condos. Is that an urban myth? Is that what's the?
Well, back in the day, Santa Monica had a law where apartment buildings could be legally converted to condos. We don't have that anymore. So you've heard this morning about the Ellis Act. That's probably the most common way that owners can go out of the rental business, and if they get the proper permits and get permission, tear down the property and build a new set of condos. That does happen. So that's, unless I'm wrong, that's really pretty much the only way to go now. There's no more, you can't convert the existing structure from apartments to condos anymore.
So you have to tear it down and build.
Correct. Anybody else? Yes.
Just really briefly, do you guys do consultations about moving forward? If somebody comes up with information and wants to know what kind of protection or legal protection and, whatever is shared with you guys, doesn't have to come out of the room?
We do it all the time. The question is whether we do consultations that don't go forward into a legal court action. And again, we don't consult giving legal advice, and there's that fine line that's sometimes difficult. But we can advise about what the law says, and we can listen to your situation and see if it sounds like something that we would encourage you to bring to us as a complaint. Okay? Okay, thank you all very much for coming out on this blustery day. Appreciate it. And thank you. Yes.